my name is Norani Shira. Today I would like to talk about what are the construction disputes. Construction disputes are conflicts that arise during a construction project, often involving disagreement over contracts, payment, delays, or quality issues. For example, the first one is delays and scheduling conflict. In some cases, delay can be caused by disagreement among project participants because each of them prioritize their own timeline over the deadlines. For the second one is contractor and subcontractor disagreement. Usually this problem is over roles, responsibility, or payment terms. Discrepancies in understanding contractual obligation often lead to these issues, especially if communication is unclear between both parties. Number 3 is quality of work and material. This example is often about involving allegation between materials or workmanship not achieve the specific requirement quality of standard. So this also can contribute to the construction. This slide is what are the parties involved in construction dispute. Common parties involved in construction dispute, obviously the first one is client or owner, main contractor and subcontractor, but it can be additional parties can be included in the construction dispute, which is the consultants, architect, engineer, material supplier also can, government if applicable. Government is as client of the project. So these are the parties involved in the construction dispute. Okay, now let's look at the example real case of construction dispute. So we look at the project of Burj Khalifa, which is in Dubai. So the employer was Imam Properties and the contractor is various international construction firm because it's a large project. Okay, so the dispute is the Burj Khalifa project faced payment and contract issue between the owners and the contractors due to its size and complexity and unexpected challenges, right? Because it's a large project, so it common to have many dispute during the whole process of construction. So the resolution of this construction dispute is the negotiation between the owner and the contractors led to a settlement that resolve payment and contractual dispute. So this can contribute in enabling the successful completion of Burj Khalifa. Okay, now what is a mediation in alternative dispute resolution? Mediation is an informal and flexible process in which a neutral third party, which the mediator, assists the opposing parties in arranging a voluntary negotiation complete resolution. The features of mediation is different a bit from other resolution, which is the first one is the parties participate voluntarily, and this allow both parties to discuss the dispute without the bias from the mediator, because the mediator must be neutral to both parties. Then that the mediator not allowed to make decision because the decision making are in the hands of the parties, which between the contractor and the client. And this mediation is not legally binding, but it depends on the parties involved. If they want the process to be bind, then it can be bind. If the process of mediation fails, so the parties can still go to court.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nofaika Hana binti Nuzaini. In this video, I will explain about why we use mediations. So firstly, mediation is a quicker settlement. It usually settles problems faster than going to court. Quicker settlement in mediation means that disputes can often be settled much more quickly than through court proceedings. Unlike lawsuits, which can take months or even a year due to formal procedures, mediation sessions can often be scheduled promptly and resolved in a matter of days or weeks. Dispute helps reduce stress, save times, and allows the party to move forward without a long delay. For example, if a subcontractor stops work due to payment disputes and the issue takes 6 months to resolve in court, the contractor might have to hire a new team or delay the entire project. Secondly is economical. Economical means that mediation usually costs less than going to court. In a court case, you may have to pay for lawyers, court fees, and other expenses, which can add up quickly, especially if the cases takes a long time. Mediation is simpler and faster, so it often requires fewer sessions and less legal help. This makes it a cheaper way to solve problems, saving both money and time. For instance, a subcontractor requests an extra payment for additional work caused by unexpected site conditions. Instead of going to court, which could take months and incur high legal fees, they use mediation to quickly agree on a fair payment, allowing the project to continue without costly delay or litigation expenses. Last but not least is confidential. Protects information from being made public, unlike court cases that are open to everyone. Mediation is a private process, meaning everything discussed or agreed upon stays confidential between the involved parties. This is very important in the construction industry, where reputation, commercial terms, and also project details are highly sensitive. For example, a contractor and a client have a dispute over alleged defects in a building. They choose mediations, so their discussion and also settlements details remain private. This prevents sensitive information about construction flaws and contract terms from becoming public, protecting both their reputation and also future business opportunities.
Assalamualaikum. My name is Muhammad Nashibuddin. Right now, I'm going to talk about how to use mediation. Okay. The first step to use mediation, agree to mediate. Both parties, contractor or client, need voluntarily to try mediation, which no forced decision. And some contracts often included, is stated there, dispute shall first be referred to mediation. The second step is to pick a mediator. Choose a neutral expert, construction professional or trained mediator, or it can be selected through industry bodies like CIDB or MIARB, or any other mutual agreement. Okay, the third step is to prepare the case. Gather any documents, which contracts, emails, payment record, or any other which related to the issue, and then know the main issue. Is it unpaid invoices or delays? Need to know the main issue. And then the fourth one is mediation session. This is where the mediation session begin, where mediator meets both sides, which can be in person or online. Each parties explain their view without interruption, so we can hear both party POV, and then mediator will assess and evaluate the problems, and then they will identify common ground and suggest compromises. If it's about payment, they need to partial payment, and if it's for about delays, and they need to revise deadline. Okay, next one is the fifth and the last step for how to use mediation. Reach a deal or walk away. If agreed, sign a settlement agreement, which need to be legally binding if written properly. And if no deal, try arbitration or adjudication next. So this one is the mediation process in a flow chart. So you can see the flow of the steps from the start to the end of the chart.
Okay, when to mediate be considered. The first one is before adjudication or arbitration, which is early stage, where the parties notice early signs of conflict such as a disagreement over project milestone, payment delay or change order. It's allowed the dispute to be resolved before they escalate into the costly legal battle, and it's also useful when the issue is more about miscommunications and also misunderstandings. For example, a subcontractor believes that they are being underpaid for extra works not formally documented. Instead of filing the claim, both sides can agree to mediate early. Alright. The second one is during a project, which is mid-stage conflict. Mediation is highly effective when the construction is ongoing, so especially if the dispute threatens to delay the project. This also allows the project to be continuity, keeping a relationship intact and ensuring a timelines, so the timelines are not disrupted by a likely dispute. For example, if a client accuses the contractor for delay, but the actually problem is contractor blames that late design approval, so the mediation can be resolved by scheduling issue quickly, so the work can be continued. Alright, the third one is after project completion, which is post-project dispute. Often used after handover for project when the dispute arise over final payment, performance, or construction defects. Instead of launching a formal lawsuit or initiate to the court, so the parties can use a mediation to settle final claim in a confidential and also non-adversary manner. For example, after completion, the client finds the defects in the foundation instead of going to the court, so the parties can do a mediate to decide on repair costs and also be responsible. And the last one is when the relationship is better. In construction, we involve a lot of parties. For example, contractor, consultant, supplier, and so on. So we all work together on a multiple project. So the mediation can help preserve the business relationship by encouraging cooperative problem solving rather than a finger pointing. For example, a contractor and a developer have a long-standing relationship. So mediations help resolve the current issue while maintaining goodwill for future projects.
My name is Fatika Ida Muhammad Kamil. So now I will continue this presentation. In this part, I would like to talk about where is the mediation take place. Where mediation take place plays an important role in the overall success of the process. To ensure fairness and neutrality, the venue is typically chosen by mutual agreement between the parties involved. It must be a neutral setting that allows for open, respectful dialogue without the influence or dominance of either party. In many construction-related disputes, mediation is often conducted at professional centers such as the Malaysian Mediation Centre (MMC) or the Asian International Arbitration Centre (AIAC). These centres are equipped with experienced mediators and appropriate facilities for a structured yet informal resolution process. Alternatively, mediation may also take place at the mediator's private office or in more recent times through virtual platforms like Zoom, providing flexibility for the parties. In some conditions, particularly in construction case, the mediation can even be held at the actual project site to better understand the context of the dispute. What matters most is that the environment is private, conducive to calm discussion, and promotes trust. According to the Mediation Act 2012, the venue itself does not impact the enforceability of the settlement as long as the process is carried out voluntarily, fairly, and with the intent to resolve. Therefore, the chosen location must support confidentiality, neutrality, and collaboration, all of which are essential to the success of the mediation process. So, I will pass to the next presenter.
There are three advantages of mediations. The first one is time efficiency. The process is very fast, often resolving the dispute in a day rather than a month or a year. The second one is cost effectiveness. Mediation is generally less expensive than other LDR. It's also saving parties money on the legal fees and court costs. And lastly is confidentiality. Of course, the discussion and the outcome are very private and also protecting any sensitive business information.
So, this is disadvantages of mediation. First is non-binding unless formalized. Agreement that have no legal power unless they are written down. Non-binding unless formalized means that the agreement reached in mediation is not automatically legally enforceable. The parties involved need to put the agreement into a formal written contract or court order for it to have a legal power. Without this, either side could choose not to follow the agreement, making it harder to ensure the terms are carried out. This differs from a court judgment which is legally binding by default. Secondly is no guarantee agreement. Mediation does not always have a guarantee a solution. So, if the contractor and client cannot agree on terms, the mediation may fail. This means that the conflict could continue, causing delays in the project and potentially leading to costly legal actions. Because construction projects often involve complex issues and multiple parties, reaching a mutual agreement through mediation can sometimes be challenging. And lastly, not suitable for all disputes. In construction projects, some disputes may involve serious issues like building code violations, safety hazards, or breach of contract that require a legal judgment. Mediation might not be effective if parties refuse to cooperate or if the matter is too complex or technical to resolve informally. For instance, cases involving criminal negligence or major financial frauds usually need a court or arbitration decision rather than mediations. So mediation is not always the right choice for every construction conflict.
Guidelines. Statute and guidelines are different two things in construction law. Okay, we look at the statute first. The definition of statute is written law officially made and passed by a legislative body like the Parliament of the Malaysia. The purpose of statute in ADR is to provide clear legal rules for mediation. Everyone must follow all the rules that stated in the document. The statute made by the government or parliament. So in short, statute explains the official rules for how mediation should be carried out through the process. So now what is guideline? Guidelines is a non-legally binding document that gives advice, procedures or best practice to follow. So there are not laws like statute is a law and guideline is not a law. It's just a guideline, but they help people understand how to act properly or professionally during the process of mediation. Guideline is like a helpful roadmap. Is the guideline legally binding? No. What is the example of statute and guidelines? Okay, we go to the statute first. Example document of legal law from statute is Mediation Act 2012. We look at example from section 14, effect of the settlement agreement. So in this section 14, it's allow parties to enforce a mediation settlement agreement through the court, and if one party fails to comply with the term of the agreement, the other party may apply for a court judgment. This section gives the agreement legal strength and ensure that mediation outcomes are not ignored, but it's different for guidelines. The example of guidelines, two example, which is the first one is Malaysian Mediation Centre (MMC). One of the rules stated in MMC is a rules for mediators' role and neutrality. Mediator rules in MMC stated that the mediator must remain neutral, not take and cannot be biased between both parties. Their job is to guide the conversation, help clarify clarify misunderstanding and support both parties to find common ground. And obviously, mediator does not have power to make a decision. Okay, next we look at the AIAC, which is ASEAN International Arbitration Center. One of the rules on the document is Rule 14, which is the termination of the mediation. The mediator is allowed and can suspend or terminate the mediation process without provided the reason of termination if the issue or first one is the parties are unable to give full commitment and responsibility throughout the process. Second one is the continuation of the mediation process would cause significant harm to other parties or third parties. This means by if the process still continue and it will cause harm to maybe to contractor or maybe it can be harm to mediator itself, so the process can terminate without provide the justification.
In this section, we will explore the solution that emerged from the mediation process. Mediation encourages open communication and collaboration, allowing both parties to jointly develop practical and fair resolution to their dispute. Unlike litigation, mediation focuses on finding mutually acceptable outcomes that preserve relationship and save time and costs. Let's now look at the specific solutions that were agreed upon to resolve the construction dispute. Firstly, mutually agreed payment schedule. The project owner agreed to pay the outstanding amount owed to the contractor. However, instead of a lump sum, the payment will be made in 3 equal installments over a 2-month period. This gives the contractor the financial support they need, while also considering the cash flow limitation of the owner. Secondly, agreement on scope of rectification works. The contractor acknowledged the presence of defects in the construction work and agreed to carry out the necessary rectification based on the scope outlined by both parties. This work will be completed at no additional cost and within a mutually agreed time frame of 14 days. This solution ensures the client's satisfaction while maintaining fairness to the contractor. Thirdly, signing of a legally binding settlement. All the terms agreed upon during the mediation were recorded in a formal settlement agreement signed by both parties. This document reflects their mutual understanding and serves as a legally binding record. Under the Mediation Act 2012, the settlement may also be enforced as a consent judgment in court, ensuring that both parties are legally protected. Having discussed the practical solutions that were reached during the mediation, it is clear how this process helped both parties find common ground without escalating the dispute further. Mediation not only resolves conflict efficiently but also supports ongoing collaboration between the parties involved. So that's all for this part. I will pass to the next presenter.
Okay, next is conclusion of mediation. Mediation is best for payment issue, delays or small disagreement where both sides want a quick fix without drama, but it's not always the answer for big disputes. But it's a good first step before going to court. Mediation is a friendly, fast and low-cost way to solve argument in construction. Instead of fighting in court or arbitration, both sides can sit down with the neutral mediator to find fair solution together. And if want to solve problems without burning bridges, mediation is a best way. But if mediation fails, it already simplifies for later arbitration by narrowing the issues.